Plaintiff Attorney Survey of Structured Settlements. This presentation was created by the National Structured Settlements Trade Association, who conducted the survey, and they're solely responsible for the results. I, however, Dan Finn of the Finn Financial Group, am solely responsible for the commentary. About the past 6 months or so, the National Structured Settlements Trade Association sent out surveys to plaintiff attorneys to gauge their understanding and knowledge and perceptions about structured settlements. And what I'm going to do is go through the survey and add my thoughts and 2 cents along the way. First question up. Do you feel you have adequate knowledge of structured settlements so that you can recognize when they're in the best interest of your client? And happily, about 90% of the respondents felt that they did. Question 2, the most significant advantage of a structured settlement is, down at the bottom, the tax-free fixed nature of a structured settlement. That's the #1 selling point, clearly. And spendthrift protection is another advantage. It's worth pointing out that these weren't either or questions. Most cases, I got to believe that the attorneys felt that these were all advantages, but they just viewed the tax-free nature as the most significant advantage of a structured settlement. Question 3, the most significant drawback of a structured settlement. The 2 that come to the top of that list are lack of liquidity and locking in low interest rates. The lack of liquidity, surprisingly, is actually a good thing for a lot of people. You don't realize it, but anytime somebody that's not used to handling a large sum of money, especially, all of a sudden has access to a large sum of money, it can be overwhelming. You can make rash and unsensible decisions, and it can lead to catastrophic consequences. So many clients actually view the lack of liquidity as a peacekeeper. It makes their lives easier and will go a long way in helping protect their future. Locking in low interest rates, one thing to keep in mind there, it's all relative. Interest rates today, it's I guess the question is, compared to what? If you have a structured settlement and you're looking for something that's safe and secure, what else are you going to do that's better? In most cases, you can't find anything, not that I'm aware of, that's going to be better than a structured settlement for the same risk and return. Surprisingly, I had a client early in my career in the early 90s, who felt that he would be committing malpractice if he recommended a structured settlement that was only paying 8% guaranteed tax-free interest. So it is all relative. There are some strategies to get around the low interest rates. You can maybe have some that pay out in bond format to have a lump sum in the future so that then they can reinvest and do what they want. All things that we can talk about when clients come to us and we better understand their needs. This one just shows the breakdown according to percentages who responded to what, the reasons for not recommending a structured settlement. For what type of cases, clients, do you suggest structured settlements? This again was not a surprise. 80% felt they recognized that the minors are good candidates for structured settlements, and certainly because minors' cases are subject to court supervision, the courts are going to require only something that is very safe and secure. And a lot of attorneys, even attorneys that don't like structured settlements, tell me they like them when a minor's involved, because it helps them get through the court process easier. Because courts know structured settlements have advantages. Many of them are parents or grandparents, and they know that they would do something like this for their own children or grandchildren. Minors' cases, there are some situations when they probably aren't appropriate, and those would normally be an older minor, 15, 16, 17, when the settlement recovery is rather small. In those cases, and we have an evaluation that we do here to compare what a projected payout would be for a minor if the funds are in a blocked account versus what it would be with a structured settlement. And in certain cases, we actually recommend that they structure In other cases, we recommend that they don't structure and that they just go for the blocked account instead. And we have an analysis sheet that allows the attorney to go to court and say, here's what we've evaluated and why we're recommending a blocked account. There's also settlement trusts that sometimes are appropriate and sometimes a good option. They do have costs and fees and taxes that are involved that sometimes can offset some of the gains. So all told, it depends on the size of the settlement and what the family's trying to accomplish. Other cases where they suggest structured settlements, cases involving significant injuries, wrongful deaths, and Medicare set-asides, which are growing in personal injury cases as they have over the years in workers' comp cases. How early in the case do you contact your consultant? A week prior to mediation is good. Sometimes we get called an hour prior to mediation. As soon as I open the case, that's actually better. Maybe not as soon as you open a case, but once you're aware a case with significant exposure and significant potential where a structure might be good, getting your consultant lined up so that they can be of service to you as soon as possible is usually optimum. After a case settles, now we do have plaintiff attorney clients who know exactly what to do and how to position things so that once a case settles they can preserve the client's right to structure. But there is some risk here if you wait until after a case settles. You want to make sure that you position this thing properly so that you don't trigger constructive receipt and so that your client has the benefit of all options available to them as their case is getting ready to settle. Question 6, not a surprise here again. Most recognize that the value in a structure, actually not in a structure, what is important in handling a client's settlement is asset preservation. I can't imagine being a plaintiff attorney working hard to get a recovery for a client and how disheartening it must be to find out in a very short period of time when, as often happens, the clients go through the money and have little to show for the efforts. If a client is getting paid for a settlement because their ability to work has been compromised, that money should be available to replace income that they're no longer going to be able to accomplish, and a lump sum just simply does not do that. So recognizing that asset preservation is important, I think, is a good sign here. 7, current interest rates negatively affected your perception of structures. And 60%, this doesn't surprise me. Perception is the key word because perception is reality. It doesn't mean you won't still use them. It just means that it affects your perception. How it affects it, there's no detail here, so I don't really know how to go into this in any greater detail. But I do know that a lot of times, surprisingly, attorneys think that the lower interest rates are actually worse than they really are. And when you compare compare them with what else is available, the structures still are favorable as a settlement option. I guess it's encouraging that 40% of the clients that responded here don't think it has any bearing on it. And this makes sense if you think, again, that an individual that's been harmed, or let's say it's a wrongful death where a family needs, say a principal wage earner was killed, and now the family needs to have cash flow and replace wage loss into the future. It doesn't really matter what interest rates are. You just need to make sure that those funds are going to be available in the future to pay for needs as they arise. Statistics show that people will dissipate their settlement within 4 to 5 years. Now that's all anecdotal evidence, by the way. There's no real specific data that show this is true in injury settlements, but we have a pretty good idea based on what we see with lottery winners and everything else, lump sum distributions, inheritance, and so on, that people just naturally seem to go through money faster than they otherwise might. And because of that, we recommend that to a lot of our clients that they execute either a hold harmless or at a minimum document with their client with a letter that their client was presented with a structured settlement option and they chose not to enter into a structured settlement. This actually protects the attorneys in case after the fact the client spends all their money and then somehow decides they want to blame their attorney for that. They won't be able to come back to you and say, it's your fault that you made me take all my money in cash and didn't tell me about a structured settlement and all the advantages. I didn't find out about this till after the fact. There are cases, recorded cases, of where this has happened and attorneys have been sued for this kind of thing, and a hold harmless would certainly go a long way to protect you. But 75% of the respondents felt that they was either very unlikely, or neither likely nor unlikely that they would recommend such a thing. This is how it breaks down percentage-wise from the previous slide. The impact of the factoring industry, and we have specifically there J.G. Wentworth, that's the one everybody seems to know, has on your willingness to consider a structured settlement. This was actually very encouraging to me that it had either no impact, very little impact, or it was indifferent in 75% of the cases, and maybe just a medium impact in another 20-some percent. Strong impact on a very, very small number of cases. And a lot of reasons for that. I think people that you talk with when they're familiar with these TV commercials, I think a lot of them view them as something that probably benefits the advertiser more than it does the plaintiff. Whether that's true or not, I'll leave that for another discussion. But the other thing is that there are a number of companies and another of options and alternatives that do not advertise on mainstream television that probably will put the client in a better situation if they do have to convert some of their future structured settlement benefits to a present-day lump sum. All of this has to be approved by courts, by the way, and there are structured settlement protection acts in most states that govern what can and cannot be done. Question 10, have you ever structured your fees? 20% have, 70% haven't. I'd say in any given year, my personal practice, I probably range anywhere from 15% to as high as 40% of any of the business that I do in a given year is attorneys structuring their fees. It's a great option for them for a lot of different reasons. If you did answer yes and they did structure their fees, why usually? Retirement planning 80% of the time and 50% of the time is also cited. These don't add up. These are different choices, not an either-or situation, so they don't all add up to 100. But these are not surprising at all. I know a lot of attorneys that I've known for many, many years, and they're not as young as they once were, and surprisingly they don't think of their own needs as they're working their practice, building their practice. And I won't say they don't think of their needs, but they sometimes are late thinking about their own needs as they're building their practice and trying to save for their own retirement. So they get later on in the years, 50s, 60s, and they realize that they could use a little bit more money in retirement, so they start structuring their fees. A lot of guys that I do work with are much younger, and they're going to be really positioned nicely when it comes time for them to retire. But pure tax deferral is the real advantage here. If attorneys take a long time to develop a case where maybe there's a few years where they're not getting paid much money, and then all of a sudden they settle the case, they're paid their appropriate contingency fee, which might be a lot of money, and then all of a sudden the reward for that is having to pay a lot of taxes. It seems unfair that you would have to pay all your taxes in 1 year when the work that was done on it was earned over a period of time, and tax deferral is a staple of the tax code, and there is a way to appropriately address this, and with good effect if done in advance of settling the case. If you've never structured fees, why not? The biggest one, almost half, 45%, said the immediate cash needs. I guess plaintiff attorneys are no different than the rest of us. Most people have immediate cash needs. If you're a salaried worker and you get paid every 2 weeks, by the time every Friday rolls around, I'm guessing most people have that money either already spent or targeted for something that they're going to need in the pretty near future. Interest rates too low is the one that jumped out at me the most. About 25% said interest rates are too low, and that best described why they don't do it. Now, these do all add up to 100, but this is absolutely positively this group of folks are people that do need to think about this again, because because this is taxable money. It depends on whether or not how much you're going to pay in taxes this year versus what you're going to pay in taxes in a future year. And if you can arrange for your fee to be paid out over a period of time, when you project that your future tax bracket might be less than your current tax bracket, then the equivalent yields on these things grow pretty substantially. I've been able to show some situations where clients would need to earn 7%, 8%, even 12 and 14% on their after-tax cash just to equal what a structured attorney fee is going to pay. So we have analysis that we can do to help people arrive at the appropriate decision here as well. A couple people didn't know it was an option, and again, no need for tax deferral. Some attorneys just don't need it. Have you ever heard of any ancillary products? Yes and no. A lot of people have not. They list some of them here. In addition to the ones up there, we also have taxable-based structured settlements that not many people are aware is available. And there is an indexed option that has a market link to the S&P 500. It's also attractive for a lot of people that want to have some market growth potential. But of those ones that were just listed, these are the ones that the attorneys felt that they wanted to hear more about. We're familiar with all of these programs, so if you have any thoughts on those, feel free to call us and ask. Happy to discuss them with you. Somehow or another, question 15 disappeared. We're up to 16 now. Structured settlement consultants, how do they bring value? The two driving ones here are knowledge and expertise, and they explain the benefits of structured settlements. I'm going to flip to the next slide where it breaks it down. So you've got about 80% of the people that respond to this understand that the structured settlement professional knows the financial details. Most of our plaintiff attorney clients recognize they went to law school to learn the law. They're focused on other aspects of the claim. This is not their area of expertise, and they want somebody that they know and can trust to explain this benefit to them so that their clients can benefit when needed. What ways do you feel the structured settlements consultants fail to deliver value? Most of these, more than about a third said it didn't apply because they felt it was valuable, but the driving one here is, I'll go to the next page. The consultant is concerned primarily with structuring as much of the case as possible rather than identifying most favorable settlement options. I'm hoping that none of these clients were mine that were consulted, because I don't feel that we do this. We do recommend that people structure certainly portions that are appropriate, but we many times will split the case up into structuring some of the fixed needs and also investing and allocating some to be invested in something else. It all depends on what the client's needs are. Sometimes they need money up front to change their housing situation. A lot of different reasons why, but whatever the case, we certainly view a balance as being appropriate in most situations. You know, maybe the one thing I will say is that most of us in this are in this business because we believe in it, and possibly our enthusiasm for structured settlements may come off as wanting to structure too much, but in reality, we may already be familiar with a lot of other options that are less attractive, and the structured settlement might be dominant. The other one I want to take a minute and talk about: contract issuance takes too long, 15% of the time. Understand that the consultant is nobody that really has any influence over that. Sometimes where the attorney thinks, and all parties think, that the case is done, there might be outstanding documents, there might be court approvals. It can take anywhere from 6 to 8 weeks after we submit all the final documents to the life companies before the life companies return everything to us and we can deliver the contracts. The due diligence is there, everything's done properly, and everybody wants it done right to make sure that everything's issued properly. And I wish we could speed that up myself, and maybe someday along the line we'll be able to. 18. Do you work with the same consultant regularly? Yes, most people do, just like most people go to the same dentist or the same professional, or even a lot of times the same restaurants. People like what they're comfortable with, so this doesn't surprise me one bit. How do you select a structured settlement? Attorney referral. Pretty much not a surprise here either. Most of the time, if you're going to want to bring any kind of expert in, you want to talk with somebody whose opinion you value and who you know is going to recommend somebody whose name's going to be attached to it. If my neighbor, if I want to paint my house and I look around the neighborhood and I have one neighbor that painted their house and it looks great, and the other one that doesn't look so good, I'm going to go to the neighbor whose house looks good and ask for the name of that painter to get my house painted. And I don't think structured settlement consultants are much different, or attorneys in finding professionals are much different in that regard. Do you work with financial planners instead of structured settlement consultants? More than 60% said no, and almost 30% said sometimes. And I'm guessing that the no might be because they defer that to the structured settlement consultant. I have networks of financial planners that I work with. In the cases where it's appropriate, the financial planners will get involved for the financial planning part of it, and I focus on the part that I'm an expert in, the structured settlement portion. 22. Is there a settlement dollar threshold? Some say yes, but more than half say no, which I guess is a good thing. They say that if they're going to get a structure, they don't really think about the settlement threshold, they just think of structures, so they're probably pretty much pro-structure here. If there is a structure threshold, what is that? 40, 70 some percent feel that it's anything over $100,000. Clearly anything where the plaintiff's going to net 500 or more is worth considering a structured settlement. Between 1 and 500 also is a great area. And the other ones 10 to 50 and 51 to 100, depending on the situation, the person, and the type of practice the plaintiff attorney has. All of those will be appropriate. It's just individual experience. And I would say that certainly anything where the claimant's going to net 100,000 or more is pretty much definitely a good place to start. 10 to 50, 50 to 100, especially if it's a minor, those should always be considered for structured settlements. Will you utilize a defendant structured settlement consultant? 60% will not, 40% will. This might go back to the defense attorneys, how you select your structured settlement consultant with attorney referral. If a plaintiff attorney in a community is very familiar and has a lot of respect for the defense counsel and they trust their opinion, they may just go along with the defense's recommendation without incident. Our recommendation, however, and we say this regardless of whether we're talking to defense counsel or plaintiff counsel, you should have your own structured settlement expert. And the reason is you want to make sure that you can say you've done your own due diligence, that you have brought in an expert. It doesn't cost you any more or cost you any less the same amount of money, but you can have someone that you know is definitely not, doesn't have split loyalties, and will actually make sure they do the best for your client. I will say that all of my peers, and if I'm on the defense side, I'm always going to do the right thing for the plaintiff regardless, but there are situations, and I've had them happen to me, where the plaintiff solicited their own individual who they thought was a structured settlement expert, and they weren't, and all kinds of bad things can potentially happen. Most of us that are in this business know what we're doing, but why take a chance? Get your own expert, and the two of us will work it out between ourselves as professionals to make sure everything's done right. Do you prefer to be advised up front if the defense is bringing their structured settlement consultant to the mediation? 90% said yes. I think that if I'm a plaintiff attorney and I hear that a structured settlement consultant's coming, I view that as a good sign that they're very serious about the case. They're probably not going to bring somebody in if they value this as a lowball settlement, or they're not going to take it, or they're going to take a defense position. So the fact that they are bringing somebody is a good sign. Do you assume that that means they'll be paying more money? And 80% said no. They probably just view it as a good sign that they're serious about the case. And I think they recognize, because the cost of the structure is always above board these days, that it doesn't mean they're going to pay more or less, and they can always say no if they don't want the structure. And the last question here, do bank minimum investments requirements affect your decision to bring a structured settlement consultant in the process? Not quite sure I follow this one all that much, but 85% of the folks said no. So all told, that is it. Thank you to the board of directors and the structured settlement of the National Structured Settlements Trade Association. Very happy to share these results with you. If you have any questions about any of it or want to talk about anything further, feel free to reach out to me through our website, dan@finfinancialgroup.com, or call us at your convenience, 800-531-7466. Thank you very much. Have a great day.